Tonight on It's the Law, we're covering self-defense. Former Paralympian Oscar Pistorius admitted he shot and killed his girlfriend last year, but the athlete testified just 2 days ago it was a tragic mistake. Jay Davis is here to weigh in. So let's kind of go through some of the facts for everybody. Pistorius admitted to shooting and killing his girlfriend, but claims he thought she was an intruder. Now, if a similar crime were to happen in Georgia, would that person go on trial for murder?
Probably.
Okay.
Probably. Self-defense is going to be an affirmative defense, which means you have to argue that that's what it is. It doesn't come as a natural excuse for something. So in this case, you kill somebody, particularly in a bathroom, somebody that you know that had the right to be there. That creates a lot of problems. So they're probably going to go on trial.
Now, they're on trial now. So in terms of self-defense, what would a person then need to prove in order for a jury to decide, hey, yeah, maybe that was committed in self-defense? It's got to be a tough case to plead.
Yeah, self-defense, murder, which is what he's going to be accused of here and what he'd be accused of here in Georgia, is going to require that you intended a malicious act, that you intended, that you had the thought and the intent to commit a crime. So if you can excuse that by saying, I was just really confused, that actually is an excuse for a crime. But there's other smaller crimes, lesser crimes that could be like negligence, recklessness, other types of things that would still be in effect.
From what you've seen, you know, in going through self-defense trials here in the Peach State, have you seen a lot of trials change from maybe someone was accused of murder and then there was a lesser charge brought against him or her based on self-defense as a motive?
That happens a lot with murder, coming down to some sort of version of manslaughter or some lesser version. That happens a lot, and a lot of times, particularly if there's a self-defense claim, that could be a factor in considering whether or not they might adjust the level of it. If it's a good self-defense claim. Here, I think you got a problem when you've got somebody. I mean, I'm all about, you know, constitutional rights to bear arms and that kind of stuff, but that comes with some responsibility, and shooting somebody in your home that has a right to be there starts being on the wrong side of that.
Quickly, he had emotional testimony. We saw that. Do you think he's going to get off, or do you think he might be?
I don't think anybody's believing the emotion. I don't think it was that emotional.
All right, Jay. Thanks for weighing in. Of course.